Welcome to today's episode of Preventing People Problems, a podcast brought to you by the HR department. Are you worried about being taken to tribunal, or maybe you're going through this right now? Today we're talking about ACAS, to settle or not to settle, and the tribunal hearing itself. Hello and welcome to today's episode of the Preventing People Problems podcast brought to you by the HR department. Today I'm really excited to be joined by Parmilla Minhas and Erica Burke, who came back after we did a podcast about disciplinaries because we ran out of time and we really wanted to talk about tribunals, didn't we, girls?
Yes.
We did indeed.
So just as a reminder to everyone, just introduce yourselves again. Erica?
Hi, so I'm from the HR department, Solihull, and I've been there 4.5 years.
Hi, I'm Parmilla Minhas and I'm from the HR department in West Hertfordshire.
Brilliant. So let's get straight into it with talking about tribunals, because small business owners are petrified of them, quite understandably. You never want to have to be in a tribunal. And the thing that is probably scarier than anything is when you take a call or you open the post and there's a letter from ACAS. Go. Pamela.
First thing, panic. First thing is, I think, let's be honest, you always, not always, but you're pretty confident to know that a letter is going to come through from ACAS, depending on how the relationship ended. Doesn't always have to be when a relationship ends, it can be while a relationship's still happening. First thing you would do is
have a cup of tea.
Have a cup of tea. Sit down. I mean, the thing with the first letter from ACAS, it doesn't actually really tell you very much, other than ex-employee has been in contact. And so the first thing, I guess, is to try and understand, okay, what exactly is this individual trying to claim? So that might be arranging a telephone call, if you've had a phone call, or if it's an email, is arranging a conversation with that ACAS person to understand, okay, what am I dealing with here?
Yeah, and don't delay, because obviously there's a time limit. On this, so it is about responding fairly quickly, just as you say, to understand, you know, what the allegation might be.
Because that first letter is just about early conciliation, isn't it? So we haven't actually got the tribunal application yet.
No, that's right. It hasn't actually gone anywhere at that point.
But it's a good opportunity for you to understand what their angle is.
What they're going for.
And sometimes you might have been expecting. I mean, I had this CEO one time. We did a massive redundancy, and we were counting down the days of we were going to get 60 claim forms or not. We were in that sort of space, and sometimes you suspect that it's not gone particularly well, the hearing hasn't gone well, or the appeal, so it might be coming, they might have threatened it, but sometimes it comes completely out of the blue, and that's when you're really flawed, because you haven't really prepared for it. You might have thought I've just dismissed somebody, they had less than 2 years service, it was straightforward, I didn't need to do any appeals processes, I didn't need to do anything else, and all of a sudden
discrimination.
Absolutely, something comes on you get that call from ACAS and it's thrown you. It wasn't what you were expecting.
I think the important thing, just picking up on your time frame, is, I think the common misconception is that the moment the employee contacts ACAS, that's the moment that you will find out, and that isn't always the case. It takes a lot of time, there's a lot of red tape for it to navigate its way through ACAS. So adhering to, respond straight away. Yes, there might be some cases where you've got 30 days to respond. But I've had one recently where we've had 7 days. Because it has taken so long to get through the system.
There's a big backlog at the moment.
Absolutely. ACAS have a huge backlog in getting that case out to you. So picking up the phone or setting up that call to try and understand exactly what the case is imperative.
And it's that understanding of actually what ACAS's role is, because the conciliator, I think when business owners try and pick this up themselves, they want to persuade the conciliator that they were in the right.
Yeah.
That's
not
their
their
job.
Not their job.
They want to. I mean, this is the thing. They want to. I mean, the tribunals have enough work to do. So part of the ACAS responsibility is really about saying, okay, what can we resolve now? What can we resolve now before it needs to? It could just be a breakdown. It could be something to be resolved quickly. So that's their job, and it's not to take sides. It's to inject some realism, I suppose. And take the emotion out of both parties. When something comes up, but when you do get it, there is that I haven't done anything wrong.
I've got to convince them.
Absolutely, and you kind of want to do that, and it is tempting, even as seasoned professionals as ourselves. There is still that temptation sometimes to want to go into that space, but actually that's not what they're interested in. They want to see whether there's something valid in that claim, almost to hear what if somebody's put a claim in and they're alleging something like, I don't know, discrimination or something, and then they tell ACAS, and ACAS are thinking, well, I'm not sure where you're going with this one. There is that room for ACAS to be able to push back to that individual,
but
to say,
I think before you get there, it's about saying, okay, ACAS, what is Johnny? What's his claim? What's he trying to understand? It's not about responding in that moment.
No.
And that's really important, because you're absolutely right. It's so easy for business owners to go, but I haven't done anything. It was really clear. These were the facts, etc., etc. Actually, take stock, understand what the problem is, walk away from it, and then go, okay, he is claiming unfair dismissal, or he's claiming disability discrimination, or any of the sort of discrimination angles. What steps did I take? What exactly did I do in order to reach this decision? Okay, I'm going to try, as difficult as it is, take the emotion out and present the facts back to ACAS. This is the situation, this is what happened. And then for the ACAS person, they absolutely can't say to the employee, I don't think you've got a claim.
That's what employers want them to say.
They want them to say that.
But they can use their judgment in terms of the questions they ask the person on the other end of the phone to help that person realise that perhaps they need a bit more in order to, go forward with it, perhaps in the way that they think they can. But it is a difficult one, and as an employer, they think it's going to all happen like really quickly, and they're going to have to be forced to settle. And there's such a long time before you have to make those decisions, a lot that can happen in between. So it's not to be spooked when you get it.
Because I guess that's the gut instinct, isn't it?
Yeah.
You get that letter, I want this to go away.
Yeah. Can't afford solicitors.
I'll either ignore it or I'll just throw some money at it and it will go away either way.
Because they think they're going to spend a lot of money on solicitors. Yeah. And actually, as we know in the work that we do, you don't necessarily have to. In that early stage stuff, you don't necessarily have to. So it's because things can be settled or moved or resolved
at any point
before you've necessarily engaged lots of solicitors. You just need to take stock.
It's not about the money. Sometimes people have been dismissed, they know they've done the wrong thing, but they're worried about their next job and they want a good reference. Like sometimes you can settle these cases for £1 and something else.
But it's understanding that motivation, isn't it? And that's the role I think that ACAS can play really, really well, is saying, okay, what is it exactly that the individual wants? Well, they just don't want you to say they were dismissed for gross misconduct. Okay, but that depends on the role. But I think, you were saying that business owners will kind of want to throw some money at it, but actually there's a lot of business owners that will say, absolutely not. I did everything right when I made that decision. They were the ones that were in the wrong. I will see them in court.
And this is the bit where there's that sort of how we advise them, because sometimes defending your position might be the right thing to do at the time. It also, depending on what it is, it might not be. Because there are we can't hide away, there are commercial considerations. And, cases are taking up to 2 years to go through at the moment. Now, either party could get fed up of it, at any point during that, and that could be a strategy. But actually, you might think, well, actually, they've involved, there are so many people involved in this. We're going to have to get witness statements for 20 people. We're going to have to do all of this work. Even though we know we did the right thing,
Got to defend it.
We've still got to defend it. And at that point, there may be a conversation about whether to, at an early stage, offer some money up. But again, if your organisation has a lot, you have a lot of, cases, or it's a larger organisation, you don't want people to get wind of the fact that you wish to settle these things quickly.
Yeah.
And I have worked where sometimes trade unions will, they know that's the course of action that an employer is going to take, and therefore that's what they're going for. And it's sometimes can be a cynical move.
Yeah.
And again, it's how you respond to that, but you've got to keep it in perspective and think about the good of the business when you make any of those decisions.
And in a small business, you've got to think about your own cash flow.
Absolutely.
And actually, if you get into a settlement conversation too early, that could skyrocket out of control, and you're talking about really big numbers that are really going to impact your business quite severely. So you've got to be really careful and take proper advice about how you have these conversations.
But if we went back to our earlier discussion around the disciplinary, actually, if you,
in our previous podcast,
if you've taken the right steps in the right way, you have a very clear chronology. You've got a clear account of exactly what you did, and that will help give you the confidence to be able to say to ACAS, we are satisfied that we have acted entirely fairly and proportionately in these circumstances, and we'll leave it to that for now, and see what happens. There is absolutely nothing wrong with doing that, and if you're confident, sometimes individuals will talk to friends and family, and they'll read stuff in the paper that you're going to get millions of pounds and all of this sort of stuff.
The headline numbers.
And it can be scary. And equally, as a small employer, you may think you see all this. This organisation's been charged £500,000, and this one's been doing it, and you think, oh my God, if I can just settle as quickly as possible, I won't have to do all that. But there is time.
A lot of time.
There's a lot of time, and if you've done the prep first, getting things right in the first place, it won't stop it ever happening, because people have a legal right to make a complaint. Nothing you can do about it.
Absolutely.
But actually, you help yourself.
But I think, that that's all good and well when you've followed the right process. And you've documented everything.
When you've just fired them on the spot.
But when you have
done everything wrong.
Exactly.
Absolutely.
When you haven't done any of that, and you know that there is a huge risk on going through an employment tribunal, not to mention the cost, but just the risk of losing, there can be an appetite to go, actually, I think we need to be realistic about this.
And it's, you see, I always like that bit of tactic as well. Sometimes there's a wrong and strong. Because again, you're weighing up, and I'm not saying it's necessarily the right thing, but again, if you haven't got very much money, you made a mistake. Do you want to be owning up to it straight away? You may think, do you know what, I'll wait a little bit. That person may have been opportunistic about it. Let's see how serious they are. How
much appetite they've got.
Absolutely. And just buy yourself a bit of time to kind of weigh up how big your liability could be, and what you might present to the employee in terms of, yes, well, we're still confident that
because I get in early conciliation, there's this process, this period of time, isn't there? And then there's a certificate that comes out that says you've completed early conciliation. That doesn't mean that you have no opportunity then to settle.
Correct.
Because you can constantly be communicating with the other side all the time. And can settle at any point, and can suggest that at any point. And in terms of timescales, it is going to be realistically 2 years before you actually get to tribunal.
Absolutely.
Loads of things can happen in your business in that time. Businesses can go bust in that time, and that employee's got nothing. And that is a risk for employees when there's a small business involved. Is that there might be nobody there to claim against.
And you get a sense of what, at the time they will have, there'll be information that you have to provide to the tribunal to either defend your position. So as an employer, you'll have to come up with your, what they call the grounds of resistance. So you'll have to prepare why you feel that this allegation has no merit. So that's, you put your defence together, and then there'll be There might have to be further exchange of documents if it's, I don't know, a disability. They might want to prove that it's, that exists.
Yeah.
And then you'll have a preliminary hearing. And again, you've got all of these points at which you might think, do you know what, actually, their case is stronger than I thought it was. I think we're going to have to offer up or not.
But I guess the preliminary hearing, I mean, our clients don't go to those because we do, or the solicitors do.
Yeah.
But for an employee, just a prelim hearing can be really intimidating. So sometimes that's quite a good time to suggest a settlement because they don't want to go back.
Absolutely.
Yeah, it's physically walking into it is a court.
Yeah.
You're going into a court.
Although they do some on telephone at the moment.
They've
had to adjust.
The prelims they do. But even that, you're speaking to a judge. That in itself is really quite scary. So
especially when they're sitting higher than you.
Yeah.
Yes.
And
there's more than one.
Yes.
And that old sort of adage about, the fool has himself for a client, or whatever it is, that, when you're the person that's in the middle of it, it's very emotional for an employee. If they've got very good representation, if they can't afford representation, they're going to have a sort of a no-win, no-fee person supporting them, in which case settlement is perhaps what they're looking for, because that no-win fee, that solicitor is not going to want to have to spend money.
And they're rare now, those guys, the no-win, no-fee guys.
Yes, they're perhaps, they sort of had their moment.
Yeah.
But I think, there's a lot of funds can be spent in that preparation.
Yeah.
And if you are so locked, you're not thinking about the legal side of things, you're thinking emotionally as an employee quite often. It's wrong, I just want my day in court.
It's justification.
And sometimes, and again, this is where I say, if you can call in ACAS to sort of help that conversation, you might want to sort of just keep that employee focused on the facts and the legal facts and what things are realistic in terms of what they can expect.
So sticking with that kind of emotional side of things, like, no, we did the right thing, we followed process, we did everything we should, it's a matter of principle. You get to tribunal, let's say they win, the employer wins, there's this kind of misconception that, well, they're going to have to pay all my legal fees.
It just doesn't happen.
It's fantasy land.
It just doesn't happen. It's so rare that if you think about, you've got little Johnny over here who's made his claim and he's got a no-win, no-fee lawyer, so he's not got loads of money, and the role that he was engaged.
No,
he's doing it himself.
That's more common.
You're right. That is very common. And the salary that he was on was not very high, and you've got a business over there whose turnover is bigger. Sufficient enough. A judge is not going to look too kindly and say, well, little Johnny, you are going to have to pay costs to that company that's turning over a few million a year, and it might take you 25 years to pay it back.
£15 a month.
Exactly. It's so unrealistic that actually the only cost you should be focused on as a business owner is your own. And thinking about the time that it takes, the cost that it takes. And the other thing that people don't always think about is the cost of their time.
Yes.
Management time away, preparation, thinking and worrying about it. And it isn't, we're back to this thing that says, is settlement always the right thing to do? And, commercially it feels like the right thing to do a lot of the time. But there's also that, what message does it always, what message does it give?
Does it open the floodgates?
Does it open the floodgates? Absolutely. So it's that balanced approach, but you can't ignore it if you're a small business. And even if you think you've done everything right, if that case is, broad enough, or the allegations are broad enough, they involve a lot of people, and you're going to fact find, and you just think, actually, I don't want to accept any liability for this. I can settle without accepting liability. It's kept confidential. I then haven't got the reputational issues to deal with.
And the good thing is, when a case is settled, the wording that is publicly out there is that the claimant withdrew their claim.
Yes.
Yeah.
It's not, my employer gave me a load of money.
That's right.
It's
so confidential.
So it's a good message.
Because particularly now with social media, people can say what they want to say. So it is really being able to manage the narrative. Settlement offers you the opportunity to do that you may not get, because even if you win, you might win on a technicality. That's public.
Yeah.
And that person who's made the claims against you can speak all as much as they want.
Yeah.
You know, they can. There's no
that.
closure for them. They can say whatever they want.
Yeah.
But actually, if you can lock them into a settlement, then you take control of that what that narrative is, which is zero.
It's really interesting, isn't it? Because I know that I've had a client in the past who have attempted to settle with an employee, even though they were kind of on shaky grounds, purely to get the confidentiality piece, because they knew that this particular individual was a loose cannon, probably would go to the press. Press don't always fact check stuff before it goes.
It's a juicy story.
You know, if the headline is there, then there's a value in saying, actually, let's look at this practically. If we can close this down and get the confidentiality piece there, they can control the narrative around why they've left, so they get this nice reference. You know, both parties ultimately get what they want, and the financial bit is almost, you know, secondary to it all.
Yeah. I mean, there's a lot of hurt feelings and bruised egos, isn't there, in this whole process? And you have to strip that away and get to, you know, how we're going to resolve this. Yeah. And as you said before, it may be a reference, it may be a small pot of cash.
But then let's assume we haven't settled and we've actually got to go to the hearing. Most employers don't know what that's like.
Yeah,
in our last minute of this podcast, let's talk briefly about what that actually is like.
Well, it's you know, it's naturally can be quite intimidating, you know, and you're having to ask questions. And if you've not done your preparation, you know, you've got a bundle of documents in front of you, they can ask you questions about any one of those documents.
And remembering things that might have happened 2.5 years ago.
Yeah, and the context. You know, it can be quite daunting. You know, so you do need, if you are going to go through with it, you really need to prepare yourself properly. Because it is daunting. It's not something that we do every day.
It's not.
We're not all lawyers.
Yeah. And you're absolutely right. Knowing exactly what is in those documents, knowing exactly why did I make that decision, because that's what you're really going to be pushed on and quizzed on. And can you actually stand up in that room and confidently articulate that the decision that you took was the right one, and why you took that decision, and what factors you took into consideration.
And that's what they will think about, is about your reasonableness. Even if you've done something wrong, they will think about the context and the reasonableness of it. You know, I found personally that tribunals have been, you know, pretty reasonable actually, when they've seen a slight flaw in the case and I've been able to explain it. Yeah. And they said, well, on that basis, that claimant should have taken advantage of that point. They chose not to because they were just wanting to dig their heels in and they haven't helped themselves. So actually, I think it is difficult, but the tribunals do, I think, try to be sensible and fair.
Yeah,
great.
Absolutely.
Thank you, both of you. This has been so useful. I really appreciate you coming back for a second time.
No problem.
Thank you very much.
Thank you for inviting us.
Yes. Thank you.
Thank you.